Hi guys, it's Kathy. I hope you're doing well. Okay, we're good. So today we start a judge getting in trouble. Sort of. I don't understand the words, so I don't know the right words to say because I know I'll be wrong. The judge, they are accusing him of being slow at his job. Um, and you'll see some cases are 7 years late. 7 years late for him putting the order in after the trial, after the hearing, after whatever. Linus called me this morning, guys. Linus did. Um, Linus, thank you. But so we're in Georgia. I remember I showed you those trials in Georgia where the defendants have been in jail for 18 months, 21 months, no indictment at all. And we see, I think Judge Manning is the best example of people just in there for 800 days, 600 days, no indictment, no nothing. In Georgia is crazy. This, though, is not that. Well, this is probate court. So it's not criminal. Nothing about this is criminal court. The judge is probate. The cases are probate. He's charged. But I don't think that he could go to jail. Like, it's not that kind of charge. So it's different than we've ever seen before. We've seen judges get in trouble before, so that's going to be the same. But this is apparently the second session. We missed the first session in August. I don't know how. I record Georgia as soon as they pop up. But we did. This is the second session. And here we go. So there are 3 judges on the panel. I am almost positive that the lady in black at the prosecutor table to the left, if it's prosecutor, I don't know if it's prosecutor, I think it's prosecutor, but she looks like the prosecutor on the other cases, the criminal cases we see. From the back, from her hair, from the way she talks. She looks like the same one we see in Judge Reeves' courtroom often. To the right, I think, well, we'll just have to wait and see.
In the matter of Judge Thomas C. Bordeaux Jr. We are here for the conclusion of that hearing. Are you ready on behalf of the director, Ms. Veal?
Yes, Your Honor.
Okay. Ready on behalf of the respondent, Mr. Tate?
Yes, Your Honor.
Okay. It is my recollection where we left off. I think the director had completed her cross-examination of Judge Bordeaux, but we didn't get to do any redirect that you wanted to do. Had you concluded your cross?
I had not.
Okay.
It was kind of a natural breaking point.
Okay. My recollection was Judge Bordeaux was on the stand, and he'd been directed, crossed. I wasn't sure if you were done with cross, and then I figured Mr. Wilson or Mr. Tate may actually have some follow-up questions. So, Judge, if you'll retake the stand for us, please, sir.
And because Mr. Wilson worked with Judge Bordeaux while I was out of the country, I'm going to let him.
Oh, okay, great. Judge, just watch your step. There's a couple of steps up over here.
Good to see you.
Yep.
I thought you had to go.
This is not built for right-handers or left-handers.
And I'm sorry, Your Honor, did you indicate that he needs to be sworn?
I think we probably should, just since we've been in recess for so long.
All right, Judge, will you please raise your right hand? Do you swear or affirm the testimony you will give in the matter now pending before the Judicial Qualifications Commission hearing panel will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can be seated. All right, Judge Bordeaux, where we left off back on August 26th of 2025 was our, and when I say our, your and my exchange regarding the spreadsheet that is kept in your office to kind of monitor cases that need your action, correct?
You'd asked me some questions about various lists. It's not necessarily kept in my office. I'm sent them on occasion.
Okay. They are kept on a shared drive that has been available to you for, I believe, since 2021, correct?
And I'm not trying to split hairs here. My understanding is it's kept on one of the drives that the probate court uses. I think it's the iDrive. I don't go to that one. I frankly would not and did not know how to look it up from that drive. Though maybe I should have. I'm just not very technological. But I was sent list from Wendy Williamson, the chief clerk of court, periodically.
Okay. And where we left off on August 26th was that I asked if you would be willing to provide myself and the hearing panel an updated copy of that spreadsheet, and you indicated you were not willing to provide it, correct?
The testimony, I mean, we've got the transcript, but I think you asked me whether, I'm not sure it was supposed to be an updated copy or what. You were talking about a list. I frankly don't know that I was sure then which list you were talking about, but you asked for a list and I declined to provide it. I don't think I'm charged with anything on that list. I don't think that's what the hearing's about, and frankly, I didn't know whether that was supposed to be produced otherwise. So no, I declined to produce it to you voluntarily. I think y'all subpoenaed it.
Okay. And you mentioned a subpoena, so are you aware that on that same day, on August 26th, myself and Ms. Stone went to the probate court and served a subpoena for that spreadsheet and any correspondence related to that spreadsheet?
I am now, I do not see the subpoena until maybe within the last 10 days, 2 weeks. I did not see the subpoena itself. I don't recall when I saw the response.
Okay. You recall that when I asked you about this spreadsheet or the list, whatever it is you want to call it, you indicated that you evidently had access to it, though you did not know that you had access to it, right?
It's on the iDrive, and I've been to the iDrive and probably, I'm just very, very few times until after that hearing. I don't think, I'm sure I never looked at the Wendy's list, is what we call it, on the iDrive prior to that time.
What else is kept on the iDrive?
Oh, I've hundreds of stuff. I mean, I couldn't tell you. And I'm not trying to be evasive there at all. I just could not, under oath, tell you what's on there.
Okay. For the members of the hearing panel,
They tell us when he became a judge, but I can't remember off the top of my head. Oh, I can't remember.
we prepared the subpoena, served it on the 26th, and that subpoena and the documents we got into response, or we got in response to the subpoena, we've labeled them as P2 through P25. And so at this time, and I've spoken to Mr. Tate and Mr. Wilson, at this point, I would move to tender P2 through P25.
Any objection to that, Mr. Wilson, Mr. Tate?
Your Honor, if I could address that. I think well, what the subpoena that was sent, that, we don't object to them putting that in. I've agreed to that previously, so I do not object to them putting that in.
Okay.
However, I do want to note, and we went ahead and handed you both exhibits. So the subpoena was served on Wendy Williams, and it says, provide me the list as of today. And so we, knowing that that would be subpoenaed, went and got the list. Judge Bordeaux got it, sent it to us. That's what the email is. It shows the day. You will note that apparently Ms. Williams added 4 additional cases to that list before it was produced to the JQC. And so there are essentially now 2 lists. There's the list that existed as of today.
Oh, I got you.
And then there's the list that she added 4 additional cases to afterwards. So we do not object. I told Ms. Veal, that we did not object. We would not require Judge Williams to be here to identify those, so we do not. But I do want to clarify that point, because I think otherwise the panel's sitting there thinking, why do we have 2 separate lists?
Okay, then those items are admitted by agreement.
And I would add for the record, for the panel's knowledge, Judge Williamson I'm going to call her as a rebuttal witness to explain the difference between the spreadsheet that Judge Bordeaux sent his attorneys on August 27th and the spreadsheet that she provided to us in response to our subpoena.
Okay.
All right. And so, Judge, as Mr. Tate just said, we recessed the hearing on August 26th. You then went and pulled up this spreadsheet on the iDrive the very next day, August 27th, correct?
No, ma'am.
Okay, how did you obtain it?
On August 26th, when we recessed, I went back to the court, to the probate court to work, and was trying to think, all right, well, what list? And I had no idea where it was. I mean, I totally admit, yeah, I should know where on the computer everything is. I do not.
Is that P3?
Which one are y'all calling the spreadsheet?
That's P3.
I've got something here with no exhibit number on it.
Probably are. No, there were 2 exhibits.
Yeah, that's the second one that Mr. Tate handed us behind that email. Yeah, just hadn't been marked or admitted yet.
And for clarification, this gets confusing, but there's one list that I'll call Wendy's list, that in the upper right-hand corner, it says 8/26/25. And then the one that she produced is dated 8/27/2025.
Okay.
To answer your question,
Let me show you the document, okay?
yes, ma'am.
And Your Honor, do you have to do anything to turn this on?
Are you
or is
using
that-
the document camera?
Yes, ma'am.
Got it.
All right, Judge, I believe that this has been marked R1.
So this Wendy they're talking about, we're going to hear more about Wendy. But the judge and Wendy do not get along, and they never have. He works with her every day, and they don't like each other. Oh, you're with your hillbillies, West Virginia.
All right.
Yay.
And I'm showing you R1, which is an email you sent to Mr. Tate and Mr. Wilson the day after our hearing convened, so August 27th at 4:51 p.m. And the subject is Wendy's list, and that's how you referred to it earlier. So this is when you provided your attorneys a copy of that list or spreadsheet, correct?
Yes, ma'am. If I could finish responding to your earlier question.
Sure.
I went back to the courthouse, to the probate court, which is in the old courthouse. My attorneys went with me. I wanted them to see my office, the hearing room size that we have, that sort of thing. And One of the deputy clerks was still there, and I asked her if she knew how to get the list, and she pulled it up or she pulled it off of the drive and brought it in to me.
And who was that clerk?
Nikki Poulos, she's the chief deputy clerk.
And so you had Nikki pull this spreadsheet up and bring it to you on August 26th?
Yes, ma'am.
Okay. And then what did you do between that time and when you emailed it to your attorneys the next day at 4:51 PM?
I worked on my cases.
Did that include some of the cases on this spreadsheet?
Oh, yes, ma'am. Well, let me look.
Well-
Yes, ma'am, I believe so, yes.
All right. So here's the version that you provided to your attorneys, and it's got the end date listed right here, and that's 8/26/25.
And I'm not sure what an end date means in this context.
All right. And it's got 5 cases on the first page and then 11 cases on the second page, correct?
Just a moment, please.
I'm sorry, 6 on the next page. Do you have a copy of this, Judge?
I think so. Could you move it so that I can see the upper right-hand corner? Yes, ma'am, I've got a hard copy here.
So when, and this is this the first time that you saw this version of the spreadsheet when your clerk ran it and brought it to you?
I believe so. I don't recall specifically how I know this, but my recollection is that the list had not been previously updated since I think since June of 2025. So, and I don't recall being sent, I certainly don't recall being sent the one as of August 26.
Do we agree that Judge Williamson, in addition to having this spreadsheet available on the iDrive, do we agree that she would also email you copies of this spreadsheet?
Yes, ma'am.
And she would also hand deliver copies of the spreadsheet to you, correct?
Sometimes, I don't think every time by any means. I don't, yes, ma'am, they were delivered at some of the time at least.
During the time that you knew that you were under JQC investigation, why didn't you, given the existence of this list, why did you not pull this list or keep updated copies of it with you on your desk and work from this list to get these cases moved or to get orders entered?
Well, let's be clear about a couple of things. There's a huge difference in my mind and my priorities in terms of cases where I've heard the case and haven't entered the order, which is what I think I'm basically charged with, versus cases pending in probate court that need to have something done. Because I don't speak to anybody else's court, but there are 10,000 cases in probate court that need a hearing, need something done. And I could spend 24 hours a day for 100 days doing nothing but that. So I honestly don't think it's fair to say, well, gee, why didn't I spend my time doing nothing but whatever's on Wendy's list? I have cases coming in every day, clerks coming in every day and saying, gee, Judge, this has been filed, it's got this on it, would you deal with it? I had, 4 or 5 come in Friday of last week where the clerk has done that. So some of these have no more priority than any of those. Others where there needed to be an order entered because there'd been a hearing, those should have been prioritized more. And I think I've said that every which way I could. I'm trying my absolute best not to have there be a significant delay between hearing held and order entered.
Okay. So when you saw this list on August 26th, have you done anything since the time that you saw it to prioritize getting orders entered on any of these cases that needed orders?
Absolutely.
Okay, which ones?
Give me just a moment, please. The order's been entered in Patience Blackman. I entered that on August 27th, 2025, not pro tunc to when the hearing was held.
Okay, so I want to be clear, you entered an order on the Blackman case on August 27th, 2025.
Yes, ma'am, because I realized, gee, this is what you're asking about, I better address those.
Are you aware that for months that case had been on this list, this spreadsheet?
Yes, ma'am, the months pending is
90?
well, and I don't know particularly for this case, but that column is misleading because sometimes it refers to when the case was filed, and sometimes it refers to when a hearing was held. I don't know on that particular case, but you can file a case and then have months and months of discovery. You can have months of not being to get everyone served, and so I do think that months pending is misleading. It's certainly inconsistent
90 months not being able to serve someone, 90?
as to what it refers to.
Yeah, okay. Well, we can agree that there was a hearing held on the Blackman case on November 9th of 2021,
Yes, ma'am.
and that
No,
the
not
order was
19th, I believe.
the order was outstanding related to that hearing, correct?
Yes, ma'am.
Okay. But it took all of this and me having to ask you about this spreadsheet and additional cases on it to get you to enter an order in that case, in the middle of this proceeding, correct?
Yes, ma'am, and if I may explain my answer, that was a petition to compromise that was held. It was uncontested. I went through the hearing on it. I'd asked the attorney to provide me some fairly, in retrospect, certainly insignificant information. It netted no money to the minor. It all went into, what's it called? An annuity, not an annuity, but something like an annuity with structured settlement where it pays out. The case was not harmed in any way by not entering that order.
You should
But
have
yes,
led with that.
absolutely, it should have been entered sooner, immediately, whatever. And I wish I had.
Judge, is it your opinion that probate judges are bound by the same time constraints that Superior Court and State Court judges are?
I believe there's a specific statute as to Superior Court judges. I don't know about State Court. I do not think there is any statute for probate judges.
Okay, so 159122 wouldn't apply to a probate judge, even though it says probate judges are under the same rules as Superior Court judges.
I don't remember that one offhand, but if that's what it says, then yes, sir.
I'm not interpreting, I'm just asking.
Okay, I will readily, under oath, say yes. It's too long for where you have the hearing. I should have prioritized it. I should have moved it faster and gotten it done. Sometimes there were
I don't know the lawyer's name.
good reasons. Sometimes there weren't particularly good reasons. And so regardless of whether there is a statute or not, I needed to get these entered.
But the statute allows you, doesn't it, to get in writing from both parties, an acknowledgement and, for lack of a better term, permission from the parties or acknowledgement that it's going to take you longer than 90 days. Did you ever do that?
No, sir, and I don't recall the statute specifically enough to respond to that, but no, sir, I did
All
not
right,
do
thank
that.
Can I get the number of that statute?
159122.
All right, and Judge, I'm not going to walk through each of these cases that we've recently been made aware of because you're not currently charged with delays related to these cases. But I do want to inquire about any additional orders that you've entered on these cases on this list since August 26th. Have you entered orders in any of these other cases?
Yes, ma'am. Yes, ma'am, and I'll have to go through my notes to, I presume you want to know which ones, and I'd have to go through my notes to try to give you that information.
And that's an excellent question, because I'm wondering the same thing. I think it's a prosecutor. However, this is not criminal charges, so it might not be a prosecutor. You're right. I don't know enough about this to know the words, the names. I don't know. I think this is an administrative type hearing. I don't know if, I think it's the prosecutor. It looks like her, doesn't it? Sometimes it looks like her, sometimes it doesn't look like her. And in my defense, all I ever see is her back. I never see her, the front or her face. The blonde girl's not here. They're sitting on the opposite side. So I don't know. I don't know.
Okay, Nathaniel Mitchell is one, correct? Do you remember entering that order?
Yes, ma'am.
Oh, yes.
Who compiled this list for you, Judge?
Compiled.
Exhibit P3.
Speaking of sanctions, Josh, guess what today is? Speaking of sanctions, you know this answer. Guess what today is, Josh? Oh my God. Oh my God. Guys, you don't even know what today is. You don't even know, guys. I don't know when I started the OJ trial. I just don't know. It was many moons ago. Many, many, many moons ago. We are today, the prosecution arrested yesterday. Today, we finally get to see the defense team. Oh my gosh, I'm so excited. It's July 7th, everybody.
The one we're talking about.
Oh, that's Wendy's list.
Okay.
And she phrased it as she knew about the case, I guess. Yeah.
All right, Judge, let me just show you Exhibit P26.
Abso-freaking-lutely, yes. His job is on the line right now. Absolutely.
Do you recognize P26?
Yes, ma'am.
Okay, can you tell us what that is?
That is an order denying motion to amend original petition. And if I may, in this case, this was a petition for letters of administration that was filed in a case back in 2021.
Petition for letters of administration, we're going to hear that a lot. Those are a lot of the cases that he just didn't put the orders in for. But what's really cool about this, this judge is going to go into all these cases. And it's pretty cool because we don't do probate court. So we get to hear all the stuff that's going on that we don't normally get to hear. And he tells stories about the people and the cases.
The petition for letters of administration is where you've got an intestate estate. Petition was filed by a particular lawyer who I found out later had represented this family before, she alleged that there was only one heir. That heir was the petitioner, and she had consented to everything, so there was only asset was a house and a $500 vehicle. That order was entered on December 21, 2021, less than 3 months after it was filed. In 2023, that sole heir, through the same lawyer, filed to amend the already acted upon petition, which I don't understand how you do, where you amended a petition after it's already been acted on. And she said, oh, by the way, there are a total of 5 heirs, not just me, but 4 or 5, whatever it was, siblings. And now she alleged there were this house, $30,000 in cash basically, and a wrongful death lawsuit in South Carolina, which I believe is brought through the estate. And she needed to fix that in South Carolina because the court order said, as she alleged, there was only one heir. So we have a status conference on this petition to amend, or motion to amend, an already entered petition, already acted upon petition. And she says, oh yeah, I didn't include those other heirs. And I didn't include this wrongful death case claim, this chosen action. And, you know, frankly, I thought she was lying. I think she committed a fraud on the court. And I have concerns about the lawyer who knew who those relatives were when she filed the original petition. And so ultimately, I denied the motion to amend the already granted petition, and I, about a month later, revoked the letters of administration for fraud. Frankly, I wanted to report the lawyer, probably should have, but
Okay, it's not the prosecutor. That's not the prosecutor's office. They don't do these disciplinary hearings. She's either disciplinary counsel or they just call her a special counsel.
you know, how do you deal with that? That was a pretty novel situation for me, where you've got somebody trying to amend a petition that had already been acted upon.
Okay, but point being, you didn't enter this order until August 27th of 2025, so the day after we recessed our hearing in August.
Yes, ma'am.
Okay.
Is that your signature, Judge?
Yes, ma'am. Yes,
Not a
sir.
Stamp?
Oh, no, that's my signature. I don't stamp my orders.
At this time, I'd move to admit P26.
Any objection? It's it?
And you know, there's also a second order entered in that to set aside the order appointing the administrator and revoking letters of administration. So there've been two orders entered in that
When was the second one entered?
second one was entered on September 19th, 2025.
Judge, if I understand your testimony this morning, and correct me if I'm wrong, you were asked about these at your last hearing on August 26th, and that's what brought your attention to the fact that maybe these needed to be ruled upon?
That it brought to my attention that this was going to be in the spotlight. I've got lots of cases that need action.
Right, and that's sort of my, you have a list that tells you how many months things have been pending. It sounds like you've told us that Ms. Williamson was providing these to you via electronic mail plus.
No, what that judge just said is barely true. There are hints of truth in it, but it's not true.
She'd print them out and give them to you. So whether you could access them on the iDrive is sort of immaterial, correct?
Yes, sir.
Okay. So can you see our concern that these are now other cases, and I understand that the director said she's not charged these, is that right?
Not yet, correct.
Okay. But you can understand our concern that now we have a new list of cases
He just called her director.
that shows that this might be a pattern within your office and not just isolated to the counts that have been charged in this case.
Yes, sir, but again, there are hundreds of cases that need similar action.
Is that because they're backed up or because they're filed every day and that's just the way it is?
They are filed every day, and every day there has to be triage. And,
How's that different than any other judge in the state, though?
well, I won't say that it is, except that you've got to look at where we've come from in terms of it sounds hokey, but the last 8, almost 9 years now. When I took office, we had a staff that had no idea what they were doing. Since we recessed, we had a family come in and say, in 2014 or 15, maybe 13, Daddy and Mama died. We filed letters of administration, and we've never gotten any word on what happened there. And we looked it up. The deputy clerk looked it up. Those files were in storage in Garden City, and nothing had been done. They were bad petitions in terms, but nothing had been done. They just sent to storage. And I had to call the family and said,
Thank
I've
you,
got to tell you what's
Kelly.
happened here, nothing.
Thank you for the
And it's
cheers.
been, the 5-year rule has them dismissed, and I entered an order concerning that status conference. The second batch that came, or second case that came in the last 2 months, was one that was I think another PLA, a petition for letters of administration, where the petition is sitting there. This is before I became judge. The petition is sitting there unfiled. The signed order of
Happy birthday, Violet. Happy birthday. Oh my gosh. Guys, it's birthday day.
my predecessor judge is sitting there unfiled. And it comes to our attention because the title searcher for that house that was involved is trying to figure out how the person who's trying to sell it got the house.
When you're working these hours, do you have staff members there?
Do I
I'm
have
talking
staff?
about specifically that the Saturdays and Sundays, all I forget the exact percentages, but they were both substantial where you're in the office on Saturday and Sunday.
Yes, sir.
Are any of your staff members there?
Sometimes Wendy Williamson works a lot of Saturdays and Sundays. She works very hard. Sometimes we'll have other staff members come in to work.
Have you ever asked other probate judges around the state to come in and help you?
When the first year I was here, a probate judge volunteered to send one of her staffers down to help us with the weapons
I
care.
don't mean a staff, I mean a judge.
I have not, no, sir.
Why is that?
Because I think they've got their own problems and
You think other probate judges have cases that have been pending for 90 months? Or 30 months, or 25 months, or 20 months? Have you ever heard that from colleagues?
I've not talked about it with colleagues, but I would not be surprised if there are cases. And again, you've got to draw this distinction between, and forgive my saying you've got to do this, sir, but there's a huge difference between you have a hearing and you don't get an order entered. That should be done as expeditiously as possible under the circumstances.
How many times do you ask the parties, though, to draw an order?
Can you finish that answer?
I'm sorry, I thought it was. I apologize.
I think there's a second part to that.
There's a 20th part to that if you let him keep going. Thank you so much, Violet. Thank you. I appreciate it. Hi, Lacey.
He took a breath, I'm sorry.
Me too. And cases that are long pending. I cannot stress to you how many cases we have that are long pending. That either because sometimes you can't get the parties to do anything other than to set it down for a trial, and sometimes you have to do that. But I'm working very hard. Wendy is working very hard. Now that we have a staff attorney, he's working very hard. He hears cases, she hears cases, I hear cases. I don't know, it's not my place to say, oh, we're the hardest working probate court or the biggest caseload in the state. I don't know. It doesn't really matter. I'm trying to do the job as best I can, and I work hard and I'm confident.
Are the cases on this list, are these office cases, or are these cases that Wendy and the staff attorney can take and go rule? Or are these cases that are assigned to you that you
Starts
have to
to
be the
P.
one that enters the order? It's called Wendy's list, but is this
Starts with
really
a
your
P.
list?
Hold on.
This is a list for cases that I've been involved in, and yes, she entered
Wrong button. I want to mute
the
it.
order one of these. But I guess one of the points I'd like to make is these are cases for whatever reason she's singled.
It doesn't start with a P at all. This is in Jasper. But no, that's Pickings. Thank you, Kelly. So Jasper, this is the Jasper courtroom, which is in Pickings, Georgia, I think. Pickings.
Out. But there are plenty of other cases that need a hearing, need a status conference, need whatever, and we do that every day.
Well, we agree that 90 months is a case that needs to be singled out.
Well,
The first one.
yeah, I'm just.
I mean, and let me further ask. My understanding here is the start date is this 2/8/2018. That's the date on which the pleading needing ruling is filed. So
See, that's just wrong. Just wait till you hear more, because that's just wrong. No, he's 82, I think, not retiring.
the 90 months is pending from the file of the motion, not of the case. But then you had a hearing. It took the 3 years to have the hearing, a little over 3 years to have the hearing, and another 4 years to enter the order. Does that sound like it's an expeditious use?
Absolutely not, but I don't think what you've said is accurate.
Okay, which part?
Well, a petition to compromise a case is where you've got a claim of a minor or an incapacitated adult that requires, that they need the court's authorization to settle. I don't know whether the case that was filed February 8, 2018, that's usually not a petition to compromise. Usually you have a guardianship created, a conservatorship created. That would happen. Usually the petition to compromise doesn't come along until way into the pendency of the case. We use the same case number. So you might have in an estate case, someone files a petition for letters of administration on January 1 of whatever year. And 2 years later, somebody files a petition to probate a will. Petition to probate the will is going to take priority, but if you're using this measure, the case is already 2 years old when the new petition is just filed. So that's why I'm saying months pending is not necessarily a valid measure at all. I don't know from being able to look at this whether the first thing filed was the petition to compromise on February 8, 2018, or whether there was something else filed. I would think there was something else filed, but
Well, if we go from the date of the hearing,
Yes,
it's
sir.
almost 4 years.
That's November 9th.
yes, sir.
Is there any mistake about that?
No, sir.
Okay. Can we still agree that 4 years is probably still too long?
Absolutely.
Do you ever tell the parties to draw up an order?
I'm going to tell my tables, don't worry, I'm going to get you your extra waters. triple fast as they do in Georgia.
And amongst themselves, look at it and then submit something to you?
Sometimes not very often, because oftentimes they're unrepresented parties, they're pro se. Sometimes the lawyers don't do enough probate work to get it right, but since all this started, I've asked for that more and more.
Yes, Violet, but no. So yes, they are absolutely saying that, but that's not why they're here. They're here specifically for cases where they had the trial, they had the hearing, they had the plea. I don't think there's pleas in probate court, but let's pretend there are. And they came to a decision, and the judge gave an order, like verbally in court. Like, you have to sell this house now. You have to move out. Then, after the hearing is over, the judge is supposed to write the order out and send it to the parties. And he never did. For years and years and years, the hearing was over and they were just sitting around waiting for him to write the order. So, like, in criminal courts, you'll hear the judges tell the prosecutor or the defense, send me the order, I'll sign it. Send me the order, I'll sign it. He wants to make sure that his orders are detailed. So he doesn't do that. He writes the orders himself. Years later.
I wish that were a solution I could use a lot of times, and I absolutely would. I don't have any pride of authorship here. I just want to get it right.
Did you ever go to any of the Superior Court judges and say, I need some help down here?
No, sir, because I don't know that it would work that way. I have had a Superior Court judge, someone I know, a local one, and I said, I'm in this mess. And he said, you can only do what you can do. That's not.
Yes and no. So the ones that he didn't act on right away, like you'll hear him say, it didn't make a difference in the outcome of the case, money-wise, anything like that, that I didn't get this order in right away. It didn't affect the parties at all. This order wasn't put in right away. It was already acted upon, the house was already sold, blah, blah, blah. So, no, I don't think that it's cases where people are waiting on a whole bunch of money or anything like that. So, he did push, it's not all of the cases that this happened to. He did work, and he did get cases out the door, and he did enter orders on a lot of cases, just not all of them. And the ones that he didn't is what he's being charged with.
Maybe what you're asking, but I don't know what else I could do in moving the full caseload of probate court. Absolutely, on the cases I'm charged with, I should have acted faster, should have prioritized them more. There's no question about that. But the tide comes in every day with more and more cases, and it's getting to be a bigger tide with more dementia, more population, more craziness in the world.
But again, how's that any different than the other counties in the state? And I don't mean Jones County or Jasper County. I'm talking about Cobb, DeKalb, Fulton, Albany.
I don't know that it is. That's the influx. The inflow may not be the difference. It's the level of staffing and the facilities.
Did you ever go to the governing authority and say, hey, I'm overwhelmed, I need some help out?
Absolutely.
And what was the response?
No. You'll find in the evidence where I wrote a letter to the county manager, I think maybe the chairman of the county commission. I met with the county commission chairman one time, and saying this, I believe it was in 2017 or 2018, where I laid it out saying we are horribly understaffed from my predecessor's administration. We do not have the facilities, we do not have the technology, we do not have a working case management system. Please give us more,
But they eventually did give you those things.
eventually.
Right, but
But
that's like 2021, correct?
for the staff attorney, yes, I think so.
Well, I think you had a case management system and staff attorney and more staff by 2021.
Yes, sir, but keep in mind that what that means, at least except for the staff attorney,
So they're in Jasper courtroom right now. 100% sure they're in Jasper courtroom. That's a fact. I don't know what county he's in charge of. It could be Pickens, but it might not be Pickens, because in Georgia, you can't just find a courtroom. You just, I mean, courtroom space is very, very, very limited. So that's one of his problems. He doesn't have space. There's no courtrooms available for him. So this panel of judges could have come. He could be the judge it's in the hot seat could be practicing from a different county. I don't know. He is 1,000% sure in Jasper courtroom right now.
the additional staff processes the cases, more cases coming in, more deputy clerks processing it, which means there's more coming to the judge. And which means there's more on my table, there's more on my plate, there's more on Wendy's plate, there's more on the staff attorney's plate. We use the staff attorney more as the judge pro tem than we do as a regular staff attorney.
Judge, you just testified that the governing authority said no when you went to them and asked for additional funding to support additional staff, but that is inaccurate, correct? Because
At the time, was accurate, yes. Back in 2017-18, yes, we've gotten more staff over the years.
between 2017 and today and 2025, your staff has over doubled, correct?
I believe that's correct, yes, ma'am,
Okay,
absolutely.
so when you took office, you had, I believe it was 7 or 9 full-time employees. Today, you have 21 full-time employees, correct?
I'll take your word for it, I don't know specifically.
And you have 21 full-time employees, and we're still dealing with these same issues, right?
Which same issues?
Cases sitting around awaiting your action, specifically awaiting orders from you.
Are you saying sitting around waiting on orders in cases I've already heard?
The cases on this list are cases that you have heard that are awaiting orders from you, correct?
Some of them are, most of them are not.
Okay. The other cases on this list are cases that are awaiting some kind of action from you in order to progress, correct?
Yes, ma'am, but in many ways, they're no different than any other case. If someone files a petition for letters of administration and they say, well, we don't know who all the heirs are, you need a determination of heirs. That needs the court's attention, the judge's attention to move it forward. And that's out there, and almost every case that's there needs the judge to do something.
All right, and to be clear, Mr. Lopez just asked you about this. You got a staff attorney or hired your first staff attorney in November of 2021, correct?
I believe that is correct.
Okay, and so between that time and the fall of 2024, I believe it was September of 2024, so November of 21.
Ma'am, he only got a staff attorney in 2021. It's only been 4 years. Leave him alone. He'll get to it.
To September of 2024, and that was Amy, correct?
Yes, ma'am.
Amy was employed with you the entirety of that time with the exception of about 3 months. You said she left and then she came back.
Yes, ma'am.
Okay, and then when Amy,
That was for all the guys in chat. They'll get to it. You don't have to keep reminding him every 6 months. He hurt you the first 3 times. He'll get to it when he gets to it. Right, Josh?
You left in September of 2024, you hired your current staff attorney,
I believe those dates are correct, yes.
Mr. Moyer.
Yes,
Okay. He works for you now, and you indicated that he is now acting as a judge pro tem as well.
he has for most of that time, yes.
Okay. Judge, quickly, and then I want to move on from this. You indicated that you have notes up there in reference to the orders that you have entered on the cases that are on P3. Can you refresh your recollection with those notes to let us know which orders you have entered in addition to Blackman and Mitchell?
All right. Well, all right, let's take Xavier Boyd. That's a P-22 case, which means it was filed in 2022. I entered the pretrial order on October 7 of this year. Now, this is a good example, I think, of what I'm talking about in terms of the work that has to be done on a case that I think frankly is different from how things are in state court and superior courts in terms of the judge's involvement. In that case, that was a petition to probate a will in solemn form filed in August of 2022. It seeks to probate a will and a codicil. We sent that attorney a deficiency notice, and he didn't comply, so it was dismissed on August 1, 2023. December of 2023, a second petition to probate the will was filed. This one sought only to probate the second, the codicil, what was called a codicil before. January of 2024, we sent him another deficiency notice. Then there was an order entered in June of 2024 about the heirs. In July of 24, there was an order extending the time for the caveat to be filed. In September of 2024, the court entered a scheduling order. In August of 25, we'd ordered them to have a mediation. The report came back in April of 25. Mediation said unsuccessful. The petitioner's lawyer was a no-show. So in April of 25, we set a show cause hearing for June. June 3, 2025, we had the show cause hearing as to why the case shouldn't be dismissed. They'd missed 2 mediations at that point, and whether the attorney should be held in contempt for not showing. The order entered, and this is why Boyd is on this list. It was a show cause hearing as to why the petition shouldn't be dismissed and why the attorney should not be held in contempt. I entered an order withholding determination at this time as to whether to proceed with the contempt action. I don't want to hold that attorney in contempt. I want him to do his job. And I'm happy to hold it there and say, look, I've tried to get your attention, and this may sound familiar, but I've tried to get your attention, and here's a contempt action against you. I don't want to hold him in contempt. I don't want to do anything to him other than get the case resolved. In June, we extended the time for a new mediation. They finally did the mediation in July. There was no agreement. We got the pretrial conference and ordered for September. We held that. The case is set for trial. So when you look at the number of months, the according to Wendy's list, that case has been pending for 25 months, and it has been. But it's not like I'm out on the golf course. I've been working diligently on that case, and the only thing that I think is outstanding, if I've read this right, the only thing is be reserving action on a contempt order.
Okay.
So that's Wendy's choice to put that on there.
Well, have you ever said to her, since you've been aware of these spreadsheets for years, have you ever said, hey, there's another measure that I would like you to use, start counting from this date, or this is how I want you to measure it?
No, ma'am, we don't talk a lot.
Okay.
Well, wait a minute, what does that mean?
Wendy is very bright. She's an incredible administrator. She works very hard. But she's also very critical and tends to, I don't want to argue with her.
But she works for you.
Absolutely. And it would be detrimental to the court to get rid of her. The court, not Bordeaux. Because she administers wonderfully. Does work that I could never do, number one, certainly in terms of administrating. But she's very difficult for me to work with.
Like every single office all around the world. But he's the boss. Josh, if you hold your phone like this, you can't see the screen. It gets real dark. But if you turn it like this, then you can see it. Wendy is abusing her boss. She probably is very intimidating, which is great.
And it's a quandary, and I wish it weren't like that, but that's where we are. So, yes, sir.
Are you done?
Yes, sir.
Or were you more concerned, do you see how it could look like you're more concerned about hurting some lawyer's feelings, holding him or her in contempt, than you are about the people waiting on you to do something where they can move on with their lives?
I honestly don't know how to answer that. I sometimes don't care about hurting somebody's feeling. I want to get the job done, but I also want to make it work. And I don't know what I can. I don't think it would help anything truly to hold him in contempt. I don't know that advances the situation. It's not going to make him a better lawyer. It's not going to make him practice better. He's trying to probate a will that consists of, 17, 15 different pages of just scribbles.
Well, you brought up contempt, though.
Yes, sir. I wanted to say.
Just an empty threat.
No, sir. It's not an empty threat. I've held people in contempt before. But my goal isn't to punish them. My goal is to get it to work. And maybe he's figuratively sobered up about it. I don't know that he's of that mindset. And frankly, I see the parallels here. I'm of the mindset that, y'all have my attention. And, but I don't think it would advance that particular case a moment to hold that lawyer in contempt.
Judge, you said we have your attention. Did we not have your attention when we sent 2 letters, or when the investigative panel sent multiple letters? Was that not sufficient to get your attention? Did we require to have a hearing on all this to get your attention on these matters?
I prioritized wrong. Well, I was trying to move the the mass of the cases and did not prioritize it correctly. And if, God forbid, I ever get another letter from the JQC, I will shut down my office for everything but whatever the complaint is, the concern is about.
I believe him full-heartedly. So up until this point in time, he has gotten these letters from them. And he's like, I'm going to do what I do. This is my court. I'm going to get to cases when I get to cases, because he has 10,000 cases to get through. 10,000 cases to get through. So he's like, I'm just, doing cases. I can't get them all done. There's no way I can make everybody happy. I can't. So, but now he's like, okay, fine. I guess what we think is important is no big deal. Next time I get a letter from these three people, or this director right there, I'll just, screw it to the rest of the cases. Doesn't matter. Just gonna do those cases. That's where he's at right now. He's like, screw it, I don't care.
And that's the truth.
Thank you.
So if I send you a letter about the cases that are on P3, what are you going to do?
You mean JQC is interested in these cases?
Yes, sir.
I'll drop everything and work on only those. I don't think that's the best thing for the court. It certainly would be the best thing for me.
So it would take another letter after that letter in order for you to vacate your office, like you just told Mr. Lopez?
That's all she wants right there. We just heard it. She wants him gone, period. No, nothing. She wants him out of office. But he was elected, okay? Not only was he elected into this chair that he sits in right now, he was elected after she filed these charges and the whole world knew about it. Not only was he elected, after that, he got well over 60% of the vote. So, she wants him out of there. The voters want him there. This panel has to decide, who do they listen to? The voters who knew about these charges. Now, they didn't know about the second set of charges she's about to file against him, which is, another X amount of cases that haven't been. So, the public did not know about the second set of charges. But they knew full well the first one, and they voted him in anyway. Now, what is this panel going to do? Look, we don't know yet. Even after this hearing, which is going to take us a couple days to get through, we don't know yet. They haven't decided.
If the JQC tells me that these 5 cases are important to them, they become incredibly important to me. If they don't, and please listen to this fairly, if they don't, they are there and they need to be acted on. But again, there are hundreds of other cases.
Yes, Judge, I agree with you. No, Granny, no, Violet. She's prosecuting this only because I don't know of a better word. I think the word is prosecuting, but that could be the wrong word. This is probate court. I'm just going to use the word prosecuting. And then if you want to know what the real word is, check my comments after the video, because when I say the wrong word, I get a lot of comments. Anyway, she's not the one who wants him out of office. Wants him to vacate his office. Guess who is pushing all this? Just guess. You might have gotten it by now. Guess who cannot handle him as a judge anymore? Wendy. Wendy wants him gone. Wendy is pushing all this. That might even be Wendy. No, that's not Wendy. Anyway, guess who gets to become the judge if he loses his seat? Guess who gets to become the judge? Wendy.
that are, in many ways, have more priority. Go through this. I mean, I have tried for months to get that Boyd case, for example, resolved. And I've ordered them to mediation. I've ordered them to do the pretrial order, all of these things. And the fact that this is the way that probate court is different in some ways than state and superior. State and superior have a case and, you know, one sues another, you can say, all right, you haven't done your job, I dismiss you. I do that, and there's still a will out there, or there's still an estate out there, there's still heirs out there who need to get their legal problem solved.
Wendy works in his office. Wendy he is her boss.
It doesn't go away.
They
It
don't
just
get
gets
along.
refiled with more cost and bookkeeping and administrative work for everybody. I would readily just throw some of these cases out if it solved the problem. It doesn't. I would have dismissed Boyd long time ago if that would solve it, but there's still, you know, what they're calling a will, and it's still got to be resolved. So I don't have the same, I won't call it a free hand, but I've got different considerations than state or superior court judges do. And the probate court judge has a duty, has a responsibility toward the ward or the incapacitated adult to act in their best interest. I have to go, the extra staff that we've got, not extra, the additional staff we've gotten, they go through and look to see what's going on in some cases. And I proactively have to cite administrators or guardians, conservators for not doing their job. I generate some of the cases because the administrator hasn't reported back in 3 years that he's distributed the estate. We had a case kicked up to us from magistrate court where the heir was suing the administrator for not doing that. So they come in all sorts, but they always come in and they keep coming in. And most of the cases on Wendy's list here are no different from any other in terms of needing action, needing hearings, needing something to be done on the case, which is hugely different from what I'm charged with. Cases where I've had a hearing and they need an order. And that is wrong for me not to have entered the order expeditiously. And I've tried to fix that in every way, shape, or form that I can, both for the ones before me and the ones that there are now. I've got one on my desk now that's a guardianship that was heard 2 weeks ago. And every day I try to get to that because it's got to be done. And it's not going to be 20 months or 2 months or whatever. It's got to be done. It will be done. Because I don't want to go through this again, and neither do y'all.
All right, so I've got P3 pulled up, Judge, and this is the version of the spreadsheet that Judge Williamson provided to the JQC in response to the subpoena we had to serve to get it. And I would note the last 4 cases, which would be Griffin, Jenkins, Manders, and Dilworth. Those 4 cases are not contained in the spreadsheet you sent to Mr. Tate and Mr. Wilson, which is R2, correct?
They're not on the list as it would have appeared on August 26th, which is what you subpoenaed. They were added afterwards.
Okay. And you do, have you reviewed P3 prior to
P3 is-
giving your testimony?
P3 is the 826 list or 827 list?
It's the 827 list.
Yes, ma'am.
Okay. And so we agree that the end date on P3, the one that Judge Williamson served in response to the subpoena or provided, it's got a different end date than the list that you pulled, and that end date is August 27th of 25.
Yes, ma'am.
Okay. So it's obvious then that this spreadsheet was updated between the 26th and the 27th, correct?
It was updated. 4 cases were added.
Okay.
I don't know whether any of the other cases that were already on there were were amended in any other way. I haven't compared the two. But I know that 4 cases were added from 826 to 827.
Okay, and does that concern you for some reason?
Concerned that I don't know.
Right, did it concern you that 4 cases were added when the spreadsheet was updated between the 26th and the 27th?
Yes, ma'am.
Okay, so you didn't spend
Hi, Debbie. I haven't seen you for a while. 10 months. Yay, thank you.
any additional time, given that concern, comparing the two, comparing R2 and P3, given that you were concerned?
I'm not sure I understand your question. I thought you asked me whether I was concerned that Wendy was asked for the list as of August 26, and she gave one on August 27 that had 4 additional cases than were on the one that she was asked for. I don't know why those were added.
Okay, but the fact that they were added, did that cause you concern?
Yes, ma'am.
Okay. Given that concern, did you not closely review R2 and P3 to see if any other changes on the cases on those lists had been made in P3?
I did not.
Okay. All right, Judge, so the hearing panel, you've admitted almost every charge in each set of formal charges. So really, I believe what they will be spending the most time on is determining what sanction to recommend, if any, to the Supreme Court. And so in thinking through that recommendation, I want to highlight a few things before I conclude my questioning. From the time you took office until today, your staff is doubled, right?
Approximately, yes, ma'am.
And one of the things that we've heard during this hearing were complaints about both your prior case management system, and you also have complaints about the current case management system. But the prior one, you had Odyssey when you took office in January of 2017. And you had Odyssey from that time until your court transitioned to CJT in October of 2022, correct?
I believe so, yes, ma'am.
Okay, so you've had a new case management system since October of 2022, right?
I think we had CJT since October 22. It's been worked on significantly, and we're still, at least I'm still learning how to use it. Yes, ma'am.
You're still learning how to use CJT?
Yes, ma'am.
How often do you log in and use it?
Every day and most nights.
Have you reached out to them for assistance with learning how to navigate that program?
To them, I talked to the staff about it, yes. I don't call up CJT Inc. and ask.
You've talked to your staff about it?
Yes, ma'am. And I've got Quicken on my home computer for financial management. I've had it for 30 years at this point, or whatever it is, and I still don't know how to use it all. That's all I'm saying. I'm not trying to make a bigger point of it than that.
Do you not view one of your responsibilities as a judge as being competent in the use of tools like a case management system?
I honestly don't know how to answer that.
Okay. You said you had asked your staff about CJT. Did you ask them to help you learn it or to help you operate it?
I do.
Okay. Which members of your staff?
Primarily Nikki Poulos. I've asked Evie Simmons. I believe I've asked Jesselyn Palmer. For example, we converted from one system to another, and that left gaps or things that didn't translate right. So if we're looking at a case from 2018 on CJT, back, documents are stored in different places for the older cases than they were for the, quote, newer cases. And we're all still learning.
The majority of probate courts in this state use CJT currently, correct?
I believe that's correct.
Okay. And are you aware that all of those courts also had to transition or have their data migrated from their former case management system to the current case management system?
I don't doubt that at all, but CJT, as I understand it anyway, was primarily designed for the smaller courts that would have less and different activity than the larger, the Article 6 courts would.
Okay. Have you taken any steps then, since it sounds like CJT is insufficient for your needs, have you taken any steps to locate or identify a new case management system?
I have not. Wendy does administratively most of that and does a very good job with it. She has been on the phone with the CJT people for lots of times, and they've been able to, we've expressed what some of our needs are, and they've done what I understand to be their best to try to fix them or to make it more convenient or
Right.
workable. But I don't think I'm charged with any of that, and I don't know why you're talking about that, but that's your choice.
Okay. So we've talked about staffing, we've talked about case management system, we've spent a whole lot of time talking about these spreadsheets. And the spreadsheets or the list has been in existence since 2021 in your office, correct?
I don't know the specific date, but there have been lists, yes. I'm not trying to deny it, I just don't know the specific date.
All right, Judge,
There's no way he's the only person. There's no way he's the only judge that struggles with that new case management system. There's just no way. I bet there's a long line of judges right now who have no idea what to click. Think of Judge Crawford. He probably switched over. I wonder if he has a Wendy in his office trying to teach him how to use the new case management system. No, click here, click here. Don't point your finger at me.
I'm showing you,
My bad. Wrong button.
and this is an email that was provided in response to the JQC subpoena. Do you recognize P5?
No, ma'am.
Okay. Did you review the documents that we provided in advance of the hearing today?
Which documents?
The documents that we got in response to the subpoena.
Not all of them, no, ma'am. I looked
Okay.
at the 827 Wendy's list. I did
That's
not
the
go
only
back
thing
through
you-
all the emails.
Okay. Well, do you remember Ms. Williamson sending an email in November of 2021 to the entire staff, including you, about the introduction of the spreadsheet?
I'm not against Wendy and pro judge here. I'm not pro Wendy or and against the judge here. The judge really should have done a better job. 100%. And I've worked with, let's just say I worked with incompetent bosses before. And it's hard to work with an incompetent boss. Because you go in there and you know your shit and it's perfect. Your work is perfect, and then it's your boss that screws it all up every single day. Every day you go in. So I'm sure that's how she feels. And not only that, this is a courtroom. These are court cases. These aren't. So, if I forget the ranch at a table, it's really not a big deal. I don't get a tip, but everything's fine. Maybe they leave one bad Yelp review, maybe if I forget their ranch, maybe. But the business is mostly okay. If these are people's lives, that he has in his hands. It's not criminal, so it's not like people are going to jail or anything. But she sees what's going on. I think she's trying to make it better, but I think that she wants the job. I think that she wants him out of there, and I don't think she's trying to come up with a solution to the issue. I think she just wants him out of there. So he could have done better. But I mean, this is Georgia. Everybody has to remember, this is Georgia. He's singled out. In my humble opinion, someone who has been sitting in jail for 4 years without an indictment should have this type of reaction, not paperwork that makes really no difference one way or another if it's filled out correctly. There's way worse problems in Georgia, and this is the one we're dealing with.
Do not. Doesn't mean I didn't get it. I'm sure I did. But if you're asking, I don't know, ma'am. I don't remember that.
Did you at any time take steps to learn how to access that spreadsheet before August 26th of 2025?
No, ma'am. I was being sent it.
All right, you got your first staff attorney in November of 2021. You still have a staff attorney. You've testified previously that you have had each of those staff attorneys prepare proposed orders for you, correct?
Both of them, yes, ma'am.
Okay. And your prior testimony was that in the circumstances where you've had your staff attorney prepare those proposed orders, you went back and edited or heavily edited those orders before they were entered, correct?
Not all of them, no, ma'am.
Okay. Who did orders or proposed orders for you that you did not have to heavily edit?
I don't specifically recall which orders. I mean, as you say, this has been over 4 years, and there are lots and lots of cases, but I readily admit I'm try to write a very thorough, specific orders, and I also try to get help from people, whether they be.
You testified previously that on the occasions where you have had attorneys in the cases prepare proposed orders for you, that they were not to your liking, and so you essentially had to redo those orders, correct?
At times, I can give you a specific example. We had a hearing in a case, pretty interesting case, actually. It was a homemade document, and the question was whether or not the document should be considered a will. And it was part will, part trust, and I had my doubts. And we had a hearing on it, and I was convinced that, yes, the testator, the man who made the will, intended that to be his will and testamentary intent and all that. And I asked the attorney to
Yes, do it.
prepare an order. She did, and she did a good job, but she didn't even mention that there was a hearing. And to me, for that case, that was important, that you say, all right, this is what was filed. This is what the concerns were. We had a hearing on it. The testimony showed this, and grant it. But just saying grant it, to me, isn't what I'm supposed to do. And maybe I'm wrong about that. But in many orders, it has to be set out.
Judge Williamson has come to you specifically about some of the cases that you presided over the hearing in, and then a proposed order was pending. She has come to you and essentially offered to take the case and hold a new hearing just to try to help to move those cases along, correct?
Oops, I think I might have messed up. Is Judge Williamson Wendy? Hold on, I think I might have messed up. I think I might have confused two people in the courtroom, in his court. staff, Wendy and Judge Williamson. If they're the same person, but why would they just? I think if they're the same person, that's who gets his job. If not, it's Judge Williamson.
I don't recall specifically, but I would not doubt that. I don't think that'd be fair to the litigants.
So it's something that you would have told her no to?
Probably, yes, ma'am.
Okay.
I mean, why?
And you do not use the form orders for probate court that have been approved by the Supreme Court in Georgia, as well as the Council of Probate Court Judges, correct?
Seldom. Sometimes I do.
You said seldom, sometimes you
I
do?
very seldom use those for,
No,
for
I didn't mess up. I'm fine. Wendy is Judge Williamson. That's Wendy. She gets his job. She's the one that is bringing all this on. So if they say Wendy and if they say Judge Williamson, they're the same person.
several really good reasons, I think. I do a lot of guardianship, conservatorship cases. A lot of those involve appointing the county administrator as the conservator. And, you know, when I took office, I looked at what was in the prior files. And you've got a guardianship, a conservatorship set up where the money's supposed to be looked after. It's supposed to be accounted for. And where there's an order that just is, there's a check here and a check there and a signature, and maybe oftentimes not even all the blanks were filled in. And when that case comes back, because they often do, I'm supposed to figure out what was in that estate 5 years ago. And that put me at a disadvantage, and I decided right then and there, you've got to have a clear order, a clear, detailed order that says, this is the sources of income for the board, this is what assets he's got, this is what's oftentimes his expenditures are, and probate court doesn't have any jurisdiction over Social Security, for example. And so that's got to be factored out. And so, yeah, I write detailed orders. I do it for a reason. And I would do it much faster if I just wrote granted or denied.
I don't know if she's elected. Don't know.
But you still don't do that?
I still tend not to do granted or denied. Once in a while I will, but I don't think it's fair to anybody to do it that way.
All right, and I previously asked you about your use of...
May I interrupt you for just a moment? Let me give you one other example of not using the approved form. When a petition to compromise, and maybe this is too much in the weeds, but when you have a personal injury for a minor, for example, at least two claims arise out of that. The minor's claim, that's for their pain and suffering and for their disability and all that. It's held by, I guess, the conservator, depending on the amount. And you've got a parent's claim, which is for the loss of services of the minor and the medical bills, for example, of the minor. Those are two separate claims. The form, which has been approved by the Probate Judges Council, by the Supreme Court, conflates those. I don't think the probate court has any authority whatsoever for the parent's claim. That's their separate claim. They can assert it or not. They can assert it in any court without asserting as natural guardian or as conservator for the minor's claim. And yet the form conflates them. That's, to me, that's not legal. And I know that the Supreme Court approved it, but I don't think they're correct. So what I've done is try to separate them out, and wherever I can, get a consent order signed by everyone, separating out the parent's claim, which is theirs, and the minor's claim. I don't have a say-so over the parent's claim. But
Josh started it. Josh ripped it open.
Yeah, maybe that's kind of geeky, I don't know, but I do think that conforms with the law far more than the form does.
Okay. Last thing, you have spent a good amount of time talking about the lack of sufficient courtroom space or the lack of sufficient space to hold hearings. And you have also explained that there are now currently 3 people in your office, you included, that are performing judicial functions. So yourself, Judge Williamson, and your current staff attorney can preside over hearings, correct?
Yes, ma'am.
All right. And again, you've testified that you don't have sufficient space for a hearing, and the one space you do have is very, very small, right?
Yes, ma'am.
And I asked you about virtual proceedings, and you indicated you do not have virtual proceedings because you do not like them, correct?
And because, yes, and because they tend not to work very well. Well, time and time again, at least with our technology or our level of tech,
Thank you, thank you, thank you, thank you. You never have to pay a late fee, ever.
technology, it's sort of like how this proceeding started 2 months ago in Savannah. We delayed the hearing. It had to be delayed half an hour, I think, to get this technology working. So no, I do not like virtual hearings.
Okay.
And we're able to use now, we're triple booked on the small space we've got. We've started being able to use some of the unused courtrooms in the quote old courthouse that we're in, but those are on a request by request basis. The county won't allow us to have them set up, even though they've got the fancy new spacious courthouse now that we were in the other week. And now the county, for their plan, is to separate out the probate court judge and his chambers to the first floor and leave the rest of the court on the 5th floor. They don't understand us, they don't care.
Well, I mean, Judge, and you correct me if I'm wrong, but there are certain hearings or proceedings that you don't have to have a courtroom to preside over virtually. You could be in your office running a Zoom proceeding or hearing, correct?
Yes, ma'am.
Okay,
I had one last week, status conference.
okay. And so, but to this point, that is something that you have not done or utilized.
I do sometimes, very seldom.
Just said he had one last week. So why would you say he doesn't utilize them? Lady, say rarely.
All right, that's all I have.
Have you ever used any courtrooms on the weekends?
No, sir, I don't think, I think to do that, I know Recorder's Court years ago tried to do that, and they were told anyway that the county won't do it because of the additional security and all of that.
Same with some of my customers.
I'd be happy to do
Seriously
it on
unlikable.
weekends if the county would let us. And they'd pay the staff.
Well, but probate court, I think, is the only court that can be open. The law just says, I think, a minimum of 40 hours a week, right?
I believe that's correct. I know there's some statute concerning the number of
So you're
hours.
saying if you wanted to have court from 9 in the morning to 9 at night, the county would just say at 5 o'clock, you can't have anybody in?
I can't speak for them. I know that in the past, they
Yes.
say,
We've seen that a million times. They can't go forward because the bailiffs are like, nope, court's closed. We are closing the courthouse down. You got to go. And the judge is like, okay, we got to go, especially in Colorado. Actually, no, not especially in Colorado. In almost all the courtrooms, I see dockets on. The bailiffs are like, stop, we have to shut the court down now.
you've got to have someone, you can't just let people,
Linus, remember when I went to see Judge Fleischer and you were there? And I was like, I think I got there at like, what, 4:32. And I couldn't get in. Ramona had to let me in because it was all locked.
come into the courthouse on weekends or off hours without, basically on the off hours being escorted so they don't wander the courthouse.
But you're there most weekends.
Yes, 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 sir. I have a card I flash to get in and, but not to, zip through to get in and, so there's 8 o'clock last night, I think, so.
Okay. Mr. Wilson?
To start with, Commissioner Hyde brought up a question, and I just want to cite some authority for the hearing panel. There's a Georgia Supreme Court case, English v. Reichert. It's 280 Georgia 215, which I think is one example of case law where the Supreme Court has noted that there's no statutory authority requiring a probate court to act upon a proposed order within a specific amount of time.
Boom. Boom. How are they going to overcome that? In all other courtrooms, judges have a time frame where they have to get an order out, but not probate court. There is no time frame in probate court where a judge has to get his order out. That's the law. That is the statute that he had just read out loud. So, okay, so now this panel has to decide, do we just say screw it to what the voters voted for? They don't know what they're talking about. We'll just overrule the voters who voted him in, knowing all of this, and then they have to say screw it, whatever, we don't care what that law says. We know more than that law. We know more than the viewers. I mean, the voters, the viewers. So that's what this panel has to decide right now. Look, if you don't like the law, change it, you know? But you can't just make your own. Yes, they can. They're judges.
What year was that?
That was 2006, I believe. 2006.
Thank you.
What's the site again? I'm sorry.
280 Georgia 215.
That's
Judge Bordeaux, I want to ask you first about P3, if you could get that in front of you.
Is that August 26th?
That is the August 27th winnings list.
Should this 82-year-old judge retire because he doesn't get through cases fast enough? Absolutely. Come on, absolutely. But this is the Judicial Ethics Commission. They should follow the law first. That should be number one. We need to follow the law. You know, I mean,
That was produced in response to the subpoena.
Yes, sir, I've got it.
I believe you testified to this, but
the biggest rule we have is never, ever, ever contact anybody we see here in real life, ever. Never even think about it. But when I got to the end of this, and I saw everything that happened, like, it took everything not to pick up my phone and say, what do you want me to do to help you? Let me help you get through your caseload. Tell me what you want me to do, I'll do it. Not that I can help because I'm not a lawyer, but I just wanted to help him so badly. I'm not saying he's right and I'm on his side and blah blah blah, but you want to help someone even if you're not on their side.
this is not the first time you've seen Wendy's list, correct, over the years?
Correct.
When the list first came into fruition in 2021, did you and Wendy have some sort of agreement about how it would be used?
It would be used as a refresher of these are the cases that she thinks need attention.
She is the person in charge of compiling the list, correct?
She compiles the list, yes, sir. I don't know.
There's no spoiler alert. There's no verdict yet. We're just listening to the hearing. We don't know what's going to happen.
How she does it or how she chooses it, but yes, sir, she compiles it.
And what is your understanding of how often she would compile the list?
My recollection is that the original agreement was that she would send it out monthly, and frankly, that we would discuss it. I don't know that that's written down anywhere, but that was my understanding.
Send it out to whom?
To me, email it, or put it in my door.
And are there other staff members, are you aware of, that are contributing or updating this list?
I have no idea. I don't know how that's done. I know other staff members, well, for example, 5 times, 6 times, 7 times a week, one of the clerks working guardianship and conservatorship cases will email me and say, oh, I'm going to bring this file to you. It's a new file. Please, handle it. And the file will be put in a file drawer basically in my office, a file folder in the office, and I'll have that email as a reminder.
Do you know how many times Wendy has sent this list to you this year?
I believe 3, but I've not gone back to check it. There was a long gap over the summer, as I recall.
If I told you that the evidence she produced in response to the subpoena showed that she had sent this to you so far this year in January, in May, and in June, would you refute that?
I would not refute that at all.
Okay. So the last list that you had been presented from Wendy was in June of this year?
I believe that was correct.
Okay. When she presents the list to you, she presents it in a PDF format, correct?
Yes, sir. And then sometimes she'll put a hard copy in the door. In addition to emailing it to me, yes.
Judge Bordeaux, what have you done and what do you do with this list when Wendy presents it to you?
If it's not a hard copy, I'll pull it off the email and look it over and consider it, and along with everything else that has come in, and again, especially like the most recent one, the 827 one, there are many, many cases that have the same circumstances in which action needs to be taken to move a case forward. But she doesn't know what's on my desk, doesn't know what the 18 other clerks have given me. So it's one factor to consider, but it's not the only factor.
Wendy is a judge and an attorney. Judges are attorneys. But Wendy is a judge. Who is what guy? The guy asking him questions? That's his lawyer. And Wendy works for him.
So if I understand what you're saying correctly, this list is one certainly that you consider for information purposes, but not necessarily take it as gospel.
It's not the Holy Grail, and it's not. It's information, and I'm aware of those cases, and I'm aware of more cases.
Do you know how Wendy can just randomly select from the hundreds of cases that you're talking about that may need attention to put these specific ones on the list?
I don't know how she decides which ones, and especially with those last 4 that were added.
On P3?
Yes, sir. Those would be Ronald Griffin, Michael Jenkins, John Manders, and Robert Dilworth. I mean, those would not be my top priority listings by any means. And going through these, I can only say so much about some of them, but I mean, Michael Jenkins, for example, was actively being worked on, very actively.
I believe he did hire her. It's possible she could have been in that position when he was elected to the seat. But normally, and we know this from Judge Fleischer, when the judge loses his seat, the staff loses their seat. Not everybody, like not the bailiffs, you know what I mean? Not everybody. The prosecution, defense, they don't lose their seats, they're not. But the clerks and his staff, he has 21 staff members. And Wendy is one of them. So if he is, so he did hire her. She wasn't already there. He hired her, and they don't get along, but she does a really good job. So, no, Wendy is not a higher level than the judge. The judge is her boss. They even said it right in the hearing. The judge is her boss. He runs everything. That's why he's on the stand. His butt is on the line, not anybody else's. And he doesn't get along with Wendy, and Wendy doesn't get along with him, and she's the one that's pushing this. He can't fire her. That's illegal. He's a judge. I don't know. I don't know what's going to happen with them two.
Let me ask you about some of these cases that are listed on P3. If, Judge Bordeaux, if you'll flip to the second page, we've covered several of the cases on the first page. If you'll flip to the second page, I want to ask you about the case that's listed here as last name Richardson, Teresa Diane. Do you see that?
Yes, sir. Yes, sir.
Is that an accurate listing of that case?
It says bench.
Let me ask you this way. Is that case name correct?
Well, no, and yes and no. This is, and I think I can say this. That is a case where there is a very, very elderly woman.
He can
who
fire
had-
her if he has cause, if she does something wrong. You can't just fire someone. It's illegal. So he would have to he would have to have a good cause to fire her.
Has two children who she appointed both of them separately as, gave them power of attorneys. And this case number, I believe, is for a suit that's been brought by one of those agents against the other, saying that, oh, he or she's abused the financial authority given. There's separately another case, and I feel certain it doesn't bear the same case number, but it's about a guardianship conservatorship, same parties. So frankly, it's not, we've only been, well, I don't know that. It's, your question is about the style of the case, and I don't know the correct style for a dispute between attorneys in fact. I think you could make it a he versus she, but that's the name of the.
So is there more to it than a bench trial being needed?
Yes, sir.
So the chart's not accurate in that regard?
Let me read it. I've got a very small version here. Make sure I'll
I
see.
do too.
You've got better eyes than I do. Right. Yes, sir, that's not at all an accurate statement of what happened, what that case is. But this actually the JQC knows about.
You mean the director or the investigative panel? Because I do not.
Yes, sir. Excuse me. I'm sorry.
Did somebody hear
We
that
did a
whistling?
scheduling order in that.
Was that, or is that just me? Do you hear whistling? Is somebody whistling into their microphone?
Case back in September of 2024. There was discovery. We set a trial date in June for July, and the case was scheduled for trial on July 22. On July 14 of 2025, the respondent filed a motion to recuse me. On July 15, the next day, I issued an order on the motion to recuse, saying that there was sufficient reason to go forward with the recusal, and that was assigned to a Superior Court judge. And that hearing was held, and the Superior Court judge denied the motion to recuse. And, but because of that filing, that date of that filing and all of that, starting on July 14, the hearing that was scheduled for July 22 had to be vacated. And since then, there were two more motions to recuse filed. One involved, according to the attorney, he filed a JQC complaint, or at least I'm not sure what it's probably called, but a complaint with the JQC. This is in, I guess, August, about me denying the second motion to recuse. It also conveniently took the case further on, so I couldn't schedule it. And for the third motion to recuse, he threw in lots of different grounds for the recusal. They were untimely. They were, even if you believe them as you're required to, they wouldn't apply. The only thing that I said, okay, this does set forth a sufficient ground to send it forward for the Superior Court was the filing of a complaint against me with the JQC. I don't know what's in that complaint. I'm not sure what's in it at all. I have no idea. And that's being considered, I guess, by the JQC now, but the Superior Court judge who heard it said, all right, I recuse you. And, which is his ruling, and that's his ruling. And so I can't act on that case.
That case should, I mean, you're done with that case.
Yes, sir.
So's your entire court, right?
Yes, sir. And we're waiting right now for the Superior Court judge, the chief judge of the court to appoint somebody to hear it. I don't
Well, that's
think,
not your problem.
not my problem, thankfully.
And that's Richardson.
Sir?
That's the Richardson case.
Yes, sir.
Judge Bordeaux, let's talk about the next case down, Penny Randall.
Yes, sir.
That case is listed as needing trial rescheduled. Do you see that?
Yes, sir.
And that's it for today. That's what's going to happen for the next couple of days, guys. And it gets worse because here's what happened. This trial, this hearing is 7 hours long. And it was huge. And I already told you yesterday the struggles I went through just to get it. I got it. But the computer that I got it on was barely able to handle something that huge. And because of that, I couldn't do any other work. None. Until I got this hearing off of that computer. But it was huge, so I couldn't just get it off that computer and have us watch it. I had to split it into chunks. This chunk, I waited until he finished the sentence and then stopped it. I am 100% sure I forgot to do that with the rest of the chunks. So that means tomorrow it's probably going to stop right in the middle of a sentence. I know it because I don't have good luck. There's no way. I luckily just paused it in the middle of a sentence. Instead, I made the chunks identical sizes. They're identically the same size. So this is how long the stream is going to be tomorrow. But it's probably going to stop in the middle of a freaking sentence. And we're going to have to figure out a way to overcome that. I already know what I'm going to do to overcome it. Don't worry. Yeah, no politics. Listen, no politics because holy crap. You know what? I can't even say anything about the holy crap because holy crap. So yeah, no politics. They create enemies, which, nope. All right. I hope you guys have a great day. I'm gonna set up OJ. Oh my God, it's July 7th and OJ. We start the dream team. The dream team comes up now. Woo! I'm so excited. All right, guys. I'll see you in a few minutes. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Chord Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Chord Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Chord Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in